Senator Greg Ludding. I have a guest here.
James Dold from Human Rights for Kids.
Mr. Chair, there is an amendment for this bill.
There's an amendment?
Yeah, okay. You got the amendment? Okay. The amendment just simply addresses some concerns from ADC regarding the first section there about educational training and rehabilitative programs. ADC already does a lot of what we are trying to do, which is essentially just make sure that anybody that is sentenced as an adult under the age of 18 is entitled to any educational and training programs that are available to anybody else in the general population. ADC just wants to make sure that we're not inadvertently putting them into a situation where they would have to mix some of the younger inmates with older inmates if that's not in the best interest of the safety of the younger inmates.
Take care of a little housekeeping first and take care of the amendment. Do I hear a motion on the amendment?
Motion.
Second. All in favor of the amendment, say aye. Aye. All opposed? Okay, now your bill can be introduced and discussed.
Thank you, Mr. Chair. With that amendment in place, there is no opposition to that first section. Prosecutors do have concerns about Section A, page 2, starts at line 4. I spoke to them a little bit earlier today, gave them my word that if the committee did approve this bill today, I would not run it in the House without making sure that we had addressed their concerns and removing their opposition. It's possible we might have to strike Section A, or we might be able to simply bump up that 5-year period to, say, 7 or 10 years. But the prosecutors simply weren't able to give us an answer today. But we have Mr. Dold, who's flown in from Washington, D.C. Just wanted him to be able to chance to speak on the bill. But like I said, I gave the prosecutors my word. I will not run this bill in the House without taking care of their concerns, and I give that same word to this committee. And like Mr. Dold to speak a little bit about the bill.
Great, thank you so much. Mr. Chairman, James Dold again for the record. I am the founder of Human Rights for Kids, which is a nonprofit organization in Washington, D.C., which is dedicated to promoting and protecting children's rights around the United States. We're very proud to have both Senator Ludding, Senator Missy Irving, and Representative Rebecca Petty as board members of them. When we work with Senator Irving and Representative Petty on Act 539, which was a bill that eliminated life without parole sentences for children here in the state of Arkansas. As a result of Senator Irving and Senator Ludding and Representative Petty's leadership on that issue, Arkansas really has emerged as a national leader. And subsequent to that legislation being enacted, Congressman Bruce Westerman in the U.S. House of Representatives actually filed another federal bill to make sure that the federal government is in compliance and sort of following the lead of the state of Arkansas. So we were really excited that Arkansas has emerged as a national leader. And SB 573 really is a continuation of discussing that issue and trying to bring about a little bit more protection for children who fall under that specific act. So one of the things that we wanted to do in the first section of this bill was just to make sure that children who are in the adult criminal justice system have access to the same rehabilitative programs and educational opportunities as other folks that are otherwise available to the adult population. So that just specifically codifies that section. In Section 2 of the bill, one of the things that Act 539 did was create a sort of a unique issue. Here in the state of Arkansas, there were no parole-eligible life sentences prior to the creation of Act 539. And so what that has required is for us to come back and make sure that those individuals who fall under Act 539 and are eligible for release and are since paroled have the opportunity to be discharged from parole so that their voting rights can be restored. And so that's one of the things that this second section is really about. So there's two ways to look at it. Really, one focuses on allowing the parole board, after individuals who've been paroled under Act 539 have served a mandatory minimum of 5 years on parole, giving the parole board the authority to release them from parole so they don't have to be on lifetime parole. And again, that's completely discretionary and up to the board. They don't have to discharge anyone from parole, so somebody could still stay on parole for the rest of their life. But if they do discharge them from parole, they'll have the ability to have their voting rights restored. This is something that's already in place here in Arkansas under Amendment 51. People who've been convicted of felonies can have their voting rights restored once they've completed their parole, paid any restitutions or fines. The one restriction, of course, for our kids is because they're on lifetime parole, they'll never have that opportunity to vote unless their parole is discharged. And I would also be remiss if I didn't say one of the reasons for Act 539 was that there was these two different subsets of kids who were impacted by recent U.S. Supreme Court decisions, Miller v. Alabama and Montgomery v. Louisiana. So there are about 50% of those individuals who got a chance to go back into court, have their sentences relooked at a judge, and some of them got sentences like time served, for example. And so they have actually finished their sentences, been eligible to have their voting rights restored, and some of them have actually even voted in past elections. For the kids, though, that were released under Act 539, they don't have that right now. And so this bill is really about trying to give them the rights to vote back. It's very limited in scope in that sense, and also just wanting to take away some of the difficulties that can be imposed upon them when they have lifetime parole. Some folks may be aware, but there's a monthly charge that they have to pay every month, which is very difficult for some of these folks as they've come out and tried to reestablish their lives. One of the great things that I think that Arkansas has really established is that in addition to the passage of Act 539, the Parole Board and Chairman John Feltz has done a really great job implementing that legislation, and they've released a number of individuals safely back into the community, and they are tax-paying citizens. They are doing really incredible things in the community, including giving back and trying to keep people, young people, out of the system. And so, again, SB 573 is about just trying to give them a little bit more opportunities in life to fully reintegrate and become full-fledged citizens of Arkansas again. Thank you.
Question from the committee? Senator Bond, Senator Gardner, Senator Ballinger, any? Senator Hester?
So this, someone convicted as a minor of anything, right? Once they get paroled, they get their voting rights back. So if they shot up a school, right? Anything. Is that right?
So only once they've been discharged from parole. So if they remain on parole for the rest of their life, they'll never get their voting rights back. This just gives the parole board the opportunity to say, after 5 years, we've determined that this person has been complying with their parole, they're not a threat to public safety, and they no longer need to be under the supervision of the state. So, but in those instances, yes.
Senator Gardner?
Thank you. Under current Arkansas law, so if a felon has served their time, but then they paid all their charges, they're offered probation and parole, and they've gone through a process, then they can get their voting rights restored. So you're actually simplifying that process dramatically with this. And the way I read it is it will place a burden on the state to restore their rights rather than them going to get their rights, which I think is a very key distinction. So the way I read it is we shall give that constitutional right back to them. It must be restored. So as soon as this happens, if the state does not automatically give that back, even though that person hasn't done even the minimum effort to sign up with the county clerk or something like that, they're automatically put back on the voter rolls. I mean, is that your interpretation of it?
Senator Gardner, James Dole again for the record. No, it's not, and the reason I say that is because it says here, unless otherwise provided by Arkansas Constitution Amendment 51, so the statute cannot usurp the Arkansas Constitution. So the Arkansas Constitution Amendment 51 makes clear that the person actually has to comply with all of those specific provisions. So what we were trying to do in subsection B there is just state that once that person has been discharged from parole, they are eligible to have their voting rights restored, subject to Amendment 51 of the Arkansas Constitution. So they would still have to comply with all of those provisions.
So what's different than what they can do now? Like what would stop a youth felony conviction from just going through the normal process and getting their rights restored? If they're taken off, is it just the ability to allow them to get their parole done quicker after 5 years? Is that the distinction here?
James Dole again for the record. For the Act 539ers, because they have life with the possibility of parole, once they're paroled, they are permanently on parole for the rest of their life. So they actually don't have the ability to register to vote or to comply with any of the provisions from Amendment 51 because they have lifetime parole. And so this provision in subsection A would allow the parole board to discharge them from parole, and then they would be able to comply with the Amendment 51 and get their voting rights restored.
Any other question?
restoring rights to minors or locating minors in Dallas parole.
Did the prosecutors give you a timeline on when they would?
Laura Compura said they hope to have an answer by tomorrow. This committee was not, to my understanding, going to meet tomorrow. Mr. Dold's time here was limited, so we're running it today. But they do hope to have an answer soon. But like I said, I gave them my word that we wouldn't run this in the House without addressing that concern.
Thank you.
Esther.
So just so I'm understanding this right, so before Act 539, we had a 16-year-old committed some horrible crimes, sentenced to life. We passed 539, he can't serve life, he or she, they get out, going to serve parole the rest of their life, or probation, parole. This is saying that particular individual doesn't have to do parole the rest of their life, or at least the parole board can say, and give them their voting rights back.
Yes, sir. So James Dold again for the record. They'd still have to serve mandatory 5 years on parole before the parole board would be authorized to discharge them from parole. There are some instances, so under the first degree murder statutes, for example, you could have a child who, let's say, didn't get a life sentence. Let's just say they got a 20, 30-year sentence. Once they've completed that term, they would actually be eligible to have their voting rights restored. Act 539 was unique just because it created for the first time in Arkansas life with the possibility of parole for juvenile offenders. So now there's a sort of a new sentence that wasn't anticipated by Amendment 51.
Yeah, what time out? Senator Legging told me this is a short bill. The bill is short, the discussion's not, and we're going to move on. I'm going to allow 2 more questions, and that's all. Y'all keep your comments short.
That's fair. Thank you, Mr. Chair.
Senator Ballard.
Thank you, Mr. Chairman. And I, maybe my question's unnecessary, but building off from what Senator Hester, but I'll even go back a step further. Having, sat on judiciary, at first it was giving the death penalty to minors. And so we actually had a court decision. We brought our code in line with that. Then it was life without parole, the same kind of thing. Had a court decision. We brought our code into that. But now it seems like, we're taking another step. And while, I am all for felons having their voting rights restored, we are fairly liberal when it comes to that in Arkansas, and that's good that it is something that we can do. But what I'm a little bit, my question is, okay, so where does it stop? We're only talking about with this group of people, the ones that have committed the crime is heinous enough that they were tried as adults and that they would be eligible for the death penalty, but for the fact that they're minors. They would be eligible for life without parole, but for the fact that they're minors. And so now the question is, is it really warranted that now we would restore their voting rights or any of the rights, if otherwise, but for the fact that they're minors, they would still be in prison at least for the rest of their life. I mean, like is this, so this is the last bill that this session is going to be brought, or next session, what are we giving them?
I can't speak to what some other lawmakers might decide to
Right.
bring forward in the next session. I apologize. But.
Yeah.
Senator Gardner.
I'll make a statement when we
Make
get
a
to
statement. Any other questions? You want this after we close?
assuming that we get a motion for debate.
Okay. Good. No one signed up to speak for or against this. Anyone in the audience wish to speak for or against this? Would you like to close the bill?
Just very briefly, that section that seems to be giving most people the most grief, that section A, is the one that's likely going to change to address concerns from prosecutors. Like I said, give you my word that I won't run this in the House until we address that concern.
Just
Bowser, you turn your mic on.
Yes, sir.
thinking this through, it says up here that we're not going to prevent them from participating. I'm back on page 1. I'm back on something else. That we're not going to prevent them from participating in any educational, training, or rehabilitative program. I assume the department had thought through that. I mean, is considering working out on the farm, is that a rehabilitative program? And if so, if somebody's, I guess we could have someone that's 17 there. There's no problem. We don't have any issues with allowing someone that's underage to do anything like that. I mean, I just want to make sure that we fully thought every program through age
getting-
limits and things like that.
I'm getting a thumbs up from ADC.
Okay, thank you.
Pleasure. As amended. Second. Senator Carter,
Thank you.
Senator Higgins, you turn your mic off.
Representative, or Senator Leding, I believe you 100% you'll change this in the House. The problem is I don't know if I can support it in its current form. So if you were amending out that section, as section 2, I'd be 100% supportive of this. If you wanted me to, I'd run in the committee assuming it meets that criteria. That's my problem with voting today. And one little quick caveat on that, we keep calling them children. Some of these men and women who were 16, 17 years old who committed heinous crimes. I think there's a big distinction between calling a 12-year-old kid who made a mistake versus a 17-year-old who could have raped, killed somebody else, a child. I think we need to make sure that's clear. So thank you.
All in favor, say aye. Aye. All opposed, say no.
No.
I need a roll call on that.
Senator Sample. Senator Hickey. Senator Hester. Senator Bond. Senator Davis. Senator Ballinger. Senator Gardner.
No.
Motion passed. Motion passed.
Thank you, committee.